Mr. President, Your Excellencies, my name is Josephine Götze, and together with my co-agent, Ms. Marie Kolb, I appear on behalf of the applicant, the Democratic Republic of Seitan. In the next 20 minutes, I shall address the submissions concerning the standing of Seitan, as well as the violation of animal rights by Tempeh, and I will also explain why Tempeh cannot validly rely on its treaty reservation. My co-agent will then, in the next 20 minutes, address the last two submissions, and we respectfully reserve 5 minutes for our rebuttal. May it please the Court. Your Excellencies, in the heart of Tempeh, behind closed doors, there exists a silent suffering. Millions of sentient beings, creatures who can feel pain, fear, and longing, are born into confinement only to die prematurely. Usually, their cries go unheard and their suffering unseen. But today, in this courtroom, we will not turn away. This case is about more than law. It is about the world we choose to create. And it is about justice for the voiceless and the moral duty of states to uphold the commitments they have once made. Tempeh stands before this court in clear violation of the Treaty on the Recognition and Protection of Animal Rights, the ART. And the ART is not a mere aspiration. It is a binding commitment to a future where exploitation is no longer the norm. Tempeh seeks to evade this obligation by invoking human necessity, but the truth is clear. Necessity is not an excuse when alternatives for culturally appropriate foods and a timely transition to a sustainable horticulture exist. Change surely is difficult, but it is not impossible. Tempeh cannot hide behind a reservation that guts the very purpose of the ART. Because sovereignty is not a license to harm, and culture is no justification for cruelty.
When you signed the treaty, you knew that the necessity reservation was there. Were there factual circumstances that changed that compelled you to rely on necessity? Because if there isn't, I don't see how necessity helps your necessity argument helps you at all. So was there any change in condition that would allow you to vitiate the necessity reservation?
Your Excellency, we submit that the reservation made by Tempeh is impermissible. In the reservation's advisory opinion from 1951, this court established that a reservation is impermissible when it contradicts the treaty's very object and purpose. And this is also stated in Article 19C of the VCLT. And
of course, let me stop you there, but of course you signed it with that reservation there. What was your understanding of what that reservation meant at the time it was signed?
Well, back in the days when the reservation was made, we had no reason to object to the reservation because it does not affect the relation between our state and the reserving state, Tempeh. Also, we even back then believed that it was impermissible, so it had no effect on the treaty obligations that Tempeh has to fulfill.
If you said that it wasn't, if you felt at the time you signed it that it was meaningless, then how can you have said that your agreement was valid at the time that you made it?
Well, because we agreed to this treaty without any reservation. Tempeh made a reservation, and we submit that this reservation was impermissible. And as a consequence of that, Tempeh is still bound by the ART because it never showed any contrary intention.
You will note that Article 12 bis of the ART actually acknowledges that human necessity, it states as a conditio sine qua non for application of welfarist protection. So it acknowledges there can be situations where one needs to move from an abolitionist agenda. So when you say the reservation is contrary to the object and purpose of the treaty, in what way is that the case?
I can surely explain how the reservation contradicts the treaty's object and purpose, which is set out not only in the title, the recognition and protection of the animal rights, but also in Article 1 of the ART, which mentions the object of the treaty itself, that is to safeguard, protect, and regulate the rights of non-human animals as part of nature. And then we also have Article 3 of the ART, which sets out the purpose of the treaty, which is promoting the rights of animals as sentient beings in litera A, the protection of and respect of animals in litera E, and the eradication of all forms of speciesism in litera G, which is further defined in Article 7p of the ART as the belief that humans are superior to other animals. Now, in its reservation, Tempeh stated that human rights shall prevail over animal rights, and therefore they put human rights above animal rights, which is against this very purpose that I just mentioned, because the prohibition or the eradication of all forms of speciesism does not allow for such a high standard or higher standard for human rights rather than animal rights. So the ART requires a complete prohibition on all forms of animal exploitation. And we understand that as a renunciation of all forms of animal uses. Furthermore, the ART rejects the approach of anthropocentrism, which is further defined in Article 7I of the ART as the affirmation that human interests prevail over other animal interests. Now, when Tempeh made its reservation and said that human rights shall always prevail, we submit that they are contradicting the very object and purpose of the treaty, and therefore their reservation is impermissible.
Why did you not object to the reservation when it was made?
Because we simply had no reason to object. This question of whether there was a timely objection or not is only important for permissible reservations and their effects on the relation between the reserving and the objecting state, here Tempeh and Seitan. The reservation is not relevant to the relation between those two states, and therefore this court has the power to evaluate the impermissibility without the objection of a state. Erga omnes partes obligations have been recognized by this court in several cases, starting with the Barcelona traction case in 1970, later on in Belgium versus Senegal in 2012, and most recently in the Gambia versus Myanmar just 3 years ago. According to this court, erga omnes partes obligations are such that are owed towards a group of states that are parties to the same treaty. Now, in cases of multilateral treaties, such as the one at hand, standing can be invoked by a state for a violation if such a potential violation affects the common interest that is protected by the treaty. The common interest of the ART is to safeguard, protect, and regulate the rights of animals, as set out in Articles 1 and 3 of the ART. And Seitan's claims are based on the violation of Article 12 of the ART, which it lists up numerous fundamental rights of animals. And since these obligations set out in Article 12 are there to safeguard, protect, and regulate the rights of animals, they are obligations erga omnes partes.
Can you tell us the difference between erga omnes partes or erga omnes and jus cogens? Is it the same thing? Do they overlap or are they different?
Your Excellency, they are different. In some cases they do overlap though. Jus cogens norms are such from which we cannot derogate as states, such as the prohibition of torture, whereas erga omnes obligations are such obligations that states have because there has been extensive legal practice by many states, and there is an opinio juris by the states that this rule is binding. And then on the other hand, we have erga omnes partes obligations, which only apply to the parties of the same treaty.
Tell me, how do you know that a treaty creates erga omnes partes obligations or not? Why is your treaty an erga omnes treaty and others would not be?
Well, erga omnes partes obligations are those that are owed to a group of states, so all states that are within a treaty regime. And in a multilateral treaty, like the one that we have, we need a common interest that is protected by the treaty. So not all rules that are set out in this very long treaty become erga omnes partes obligations. Only the common interest that is protected by it, which we can find in the object and purpose or in the first articles of the ART, they can establish erga omnes partes obligations.
Can you point us to a decision of our court that recognizes that idea?
Of erga omnes partes?
Partes obligations?
Well, first of all, the Barcelona traction case, then Belgium versus Senegal, and lastly, the Gambia versus Myanmar. Although the court did not in all cases acknowledge that there was an erga omnes partes standing, I'd say, but it did say that erga omnes partes obligations do exist. For example, in the Gambia versus Myanmar, where Gambia accused Myanmar of committing genocide, and it invoked obligations erga omnes partes under the Genocide Convention. And there, the ICJ upheld the Gambia standing and jurisdiction, although it had no particular interest, although people from Gambia were not affected by the acts done in Myanmar.
Let's go back to the point about 12 bis, right? So you say, so you acknowledge that not the entire treaty creates erga omnes partes obligation, but that there might be specific rights or specific sections that do meet that test. So what is it about Article 12 that renders it, notwithstanding 12 bis, that renders it kind of one that meets this erga omnes partes level?
So, as we can see in Article 12 bis, we have this general abolitionist approach, which is why we submit that animal rights, rather than a welfarist regime, are creating such obligations. We submit that, first of all, Tempeh violated the rights of animals set out in Article 12, which are fundamental rights such as the right to life and existence in litera A, the right to freedom, including the freedom of movement in litera G, and the right to be free from exploitation in litera J. Now, if we look at the facts, for example, in paragraph 5 and 7, in Tempeh we still have intensive and factory-based farming. That includes slaughtering of animals, which is a violation of the right to life and existence from Article 12, litera A of the ART. We also have confinement of animals, which is a violation of the right to freedom, including the freedom of movement in litera G of Article 12 of the ART. And we have animals being used and treated as commodities rather than sentient beings, which is a violation of the right to be free from exploitation from litera J in Article 12 of the ART. And since Tempeh is in violation of these rights, Seitan can make claims based on the violation of these articles or of these parts of the Article 12, and has thus the right of standing, or has erga omnes partes standing. The abolitionist approach set out in Article 12 bis of the ART requires a complete prohibition on all forms of animal exploitation. So that means that animals can no longer be used for any purposes that humans want. They are to be left alone. We, in this article, see a renunciation of all forms of animal uses. We acknowledge that it is right now very difficult for Tempeh to realize all these rights and to stick to its obligations. There must be a progressive and sustainable phasing out approach, which is why even if this court found that the reservation was permissible, it would not be applicable in this case. If there are no further questions, I would now hand over to my co-agent to address the last two submissions.
Thank you.
Thank you very much.
Mr. President, Your Excellencies, good afternoon and may it please this court. My name is Marie Kolb and I also appear on behalf of the applicant in this matter. Your Excellencies, I will continue the case for Seitan on the third and fourth submission, beginning with the third submission. Tempeh cannot rely on the human necessity ART exception. Article 12 bis of the ART grants the exceptional application of welfarist protection only if it is justified by human necessity. The appropriate legal test to evaluate which countervailing claims to rights prevails is a test of proportionality. Some national cases can be referred to that to see that this test of proportionality has been used in cases where human interests and animal interests were balanced against each other. Just to name two of those cases. First, we have the Animal Welfare Board of India versus People for Elimination of Stray Troubles from 2009 by the Supreme Court of India, and also the Astrolita monkey case from 2022 from the Constitutional Court of Ecuador. This means that a measure needs to be first suitable to achieve a legitimate goal, second, that it needs to be necessary for achieving that goal, and third, that the goal needs to trump the interest it is balanced against. First, we will start with the submission that Tempeh's omission to prohibit animal agriculture and aquaculture is neither suitable nor necessary for safeguarding vital human interests of the Tampinese population. I see that there is a hand raised.
Right, Shreya.
Sharia?
Thank you, Rana. Hi, can you tell me what argument you're using that you're supporting your citation with of Animal Welfare Board of India versus People for Elimination of Stray Cattle? I don't think I was clear on that.
Your Excellency, this case is just an example of a national case where the proportionality test, like a balancing test, has been utilized. So this was just an example to give you that this test is used in our case that we have here with the balancing.
Can you, just on that case, could you quickly walk us through what the brief facts of this case was and what the Supreme Court of India concluded, what the basis of that was?
Your Excellencies, the decision was by the Supreme Court of India, as I've already said. It addresses the conflict between the protection of stray dogs and the public safety concerns, because there were some instances where stray dogs were biting people. The case arose because of the approach of various states towards managing stray dog populations, and the central issue is whether the animal birth control rules prevail over municipal laws. The judgment indicates a clear legal stance. It also places importance on human safety. That's where the balancing test comes in. If that answers your question,
I have a follow-up there. Yeah. On the animal rights aspect of this, could you balance out mandatory animal birth control programs where dogs are rounded up on the streets of India?
We just used that case to show that in national cases, the proportionality test and the balancing act was used to see whether human interest or the interests of, in this case, stray dogs outweighs. And we can see that in some cases, human interests, like the right to conduct trade, was curtailed or could be curtailed in favor of the animal interest to not be exploited. If that concludes your question, I will now move on to our own case at hand. And I will start with the submission that in our case, the balancing of the conflicting interests shows that the supposedly affected human rights do not outweigh the rights violated by Tempeh's omission, so the rights of the animal interests. For such a balancing test, the social importance and the severity of the limitation needs to be evaluated. It must hence be determined what status a right occupies in society and to what degree it is affected. It must be considered that Article 4, litera E of the ART establishes the in dubio pro natura approach and therefore obligates state parties to choose the rule favoring non-human animals.
So in 12 bis it says that the human necessity exception applies to safeguards. Specifically, it names vital human interests such as life and liberty. So can you just explain perhaps, I mean, you've given an example of a national court that used balancing in a specific case, but can you explain more normatively why balancing is the correct kind of way to approach it rather than having, as it were, life and liberty of humans trump as a matter of course?
Your Excellency, thank you for the question. This is because of the ART establishes fundamental rights of animals. The ART also establishes that the human necessity, it is the conditio sine qua non for the welfare's protections. However, it still establishes rights of animals as fundamental rights, and the whole ART aims to implement an abolitionist approach towards our treatment of animals. Therefore, we submit that even though if we have this restriction with the human necessity, it needs to be applied only in certain cases, only when the life and liberty of people are really endangered. We can also see this in Article 9 of...
So let me stop you. Give me an example. When would it apply under in your analysis?
For example, if the life of the people are actually threatened, the life of the people of a state are protected under Article 6, paragraph 1 of the ICCPR, and it is also established a customary international.
So let me give you a hypothesis. It would take 40 years for Tempeh to readjust their economy, to be able to feed their people, and it'd probably take 30 to 40 years to readjust their economy to be able to do this. How does that not create a crisis if it causes a collapse of the Tempeh economy under your proposal to eliminate all forms of animal and aqua agriculture?
We acknowledge that it takes time and that it is challenging to reverse the system.
Let me follow it up. Sure, it takes time. Of course, any reasonable person would say that. I'm not saying you're being unreasonable, but when you signed the treaty, you knew that those conditions were there. You're not saying we want to renegotiate this. You're saying under the terms that are here now, without a change in conditions, require us to say you must do this now. Doesn't that seem almost an impossibility for any functioning society?
Your Excellency, we do not propose that it must be now. We just need some steps.
I see.
That's in line with the principle of progressivity that my co-agent has already introduced to you. Yes. It is comparable to human rights. We had a human rights treaty, but it was not an obligation to do everything perfect all at once. However, there is the principle of progressivity in human rights as well. There needs to be progress, but instead, Tempeh is even declining their welfare standards. They are even regressing and not progressing in any way or form. We are not saying that Tempeh must immediately abolish its animal agriculture and aquaculture, especially because we acknowledge that if that were the case, the rights, the food, the security would be at risk. Tempeh needs to do something. We submit that with the major contribution Tempeh has towards the climate crisis, we are affected by that. Tempeh willingly submitted and ratified to the ART provisions. Therefore, they have to make their steps towards protecting the rights of animals, the rights of nature, to advance our shared goal of a sustainable and green future. The ART has only been ratified in 2023, so there hasn't been a lot of time yet, and we hoped that Tempeh would make some progress, but as we have seen that the welfare standards declined already, even after the ratification by Tempeh of the ART, we wanted to act and wanted this court to stand for change and justice and acknowledge that the rights of animals are protected under the ART. I see there is another question.
You said that very reasonable ask that there should be progressive steps taken by Tempeh, should have been taken by Tempeh. Can you tell me 3 steps that Tempeh could have taken? And at this stage, given all of the pollution that you're saying Tempeh has caused, 3 steps that they should take now at this time to improve the environmental and animal welfare conditions. What would you like the court to direct that Tempeh does? What kind of reparations are you seeking?
Your Excellency, thank you for the question. We are first and foremost seeking the recognition that Tempeh is in violation of the ART. And we also want to seek this court to adjudicate that Tempeh needs to cease such violations and that appropriate reparations, assurances and guarantees of non-repetition are being made. So 3 concrete steps, I would say, is that Tempeh needs to cease its most pressing violation. It needs to uphold the welfare standards at least. And there needs to be, for example, an action plan.
What steps practically should the country take in its effort to recognize animal rights? And what does that look like to you? A policy, a domestic policy, certain plans for phase out? What would specific action points in those plans be?
Your Excellency, I don't know if that's my my position to actually propose, because it's Tempeh's obligation to propose the next steps. But we would suggest that they have a plan, an action plan in place that shows their commitment towards the ART. Another way is also to uphold the welfare standards, because they are not only declining in practice, but also in the judicial system. So holding the judiciary in Tempeh accountable and upholding the welfare obligations they have under other international law, national laws, and also the ART itself, that would be the first steps.
What is it in the legal framework specifically, I suppose? So there's a question about the practical steps, but there's a question about the legal framework that exists in Tempeh that needs to change to indicate the position of, as you were, progressive realization that you are describing.
So in the legal system, actually there has to change nothing really, because Tempeh and Seitan are monist states, so public international law treaties are directly in the national system.
The difficulty with that argument then is that 12 bis is talking about vital human interests such as life and liberty, and you want to basically cross out the word such as and say, well, that's an exhaustive list of human interests.
Exactly.
We submit that because of such as, there are other liberties and interests that could be invoked. However, they must be on the same level as life and liberties, and the economy, as we submit, is not on that level, especially because there are other public international law doctrines, like the necessity exception under public international law in general.
You're not taking a Marxist view then of the economy, is that what you're saying? Because it seems to me that there's always one central engine of change, and that usually tends to be the economy in most societies.
Your Excellency, that is surely correct, and we acknowledge that the economy and the right to conduct business and trade is important for people. However, there is a possibility of change. Farmers in Tempeh have the opportunity to transition towards a plant-based agriculture instead of exploiting animals. And with that, especially in light of the principle of progressivity, we still submit that the liberties are only marginally affected of the people. We urge this Honourable Court to hold Tempeh accountable, to enforce the obligations it willingly accepted, and to take a stand for those who cannot speak for themselves. The time for change is now. The law, the ART demands it, and justice demands it. Thank you, and may it please this Court.
Thank you.
Good afternoon, Your Excellencies. May it please the Court. My name is Isidora Martinez, and I appear together with my esteemed co-agent Javiera Fritz on behalf of the Respondent, the Kingdom of Tempeh. In accordance with the allotted time, I will speak for 20 minutes, and then my co-agent will present for another 20 minutes. We respectfully reserve 5 minutes for rebuttal. We submit that the Kingdom of Tempeh has not breached any obligation set by the Treaty on Protection and Recognition of Animal Rights, commonly referred to as the ART. Tempeh has a rich history of hunting and fishing, and the consumption of animals is an integral part of its culture. However, it still ratifies the ART because it recognizes the importance of a binding international recognition of animals as subjects of rights. During our plea, we will demonstrate that this court has not jurisdiction to rule over this case, that the applicant lacks legal standing to invoke the responsibility of the Kingdom of Tempeh, and that there hasn't been any breach of the obligations under the ART, particularly considering the reservation that the Kingdom of Tempeh has made to this treaty, the human necessity exception of Article 12 bis, and necessity and distress as circumstances precluding the wrongfulness of acts. To begin, I would like to submit that this Honourable Court does not have jurisdiction to rule over this case. The ART established this court as a dispute settlement method. However, Article 2 bis establishes that this court has jurisdiction to rule over disputes arising from the ART obligations. This raises the question, is there a dispute that exists in this case? before the submission by the applicant was made? The answer is no. This court has established through case law, for example, and most recently in the Order on Provisional Measures in the case of South Africa versus Israel, that it must be demonstrated objectively and through an examination of facts that both parties have opposite views on the law.
If I can stop you there, but the argument in particular of the applicants is that the reservations that your country has entered into, on which you rely, right, in the application of your law, is in breach of the treaty, and as a result of being contrary to its object and purpose. So, isn't that a dispute as to the law?
There is no dispute over the reservation, at least before the applicant's submission was made, because there was not knowledge by the part of the Kingdom of Tempeh that the Republic of Seitan objects this reservation and presumes that it's not admissible.
What you're saying is that we can invoke necessity, in essence, to negate the agreement we just made, because it's inconvenient for us. It's almost like we're taking back. We signed it and we're taking it back. So wouldn't you need to have some change in circumstance in the facts here to allow you to invoke necessity as a get-out-of-jail-free card?
You're referring to the human necessity exception or the necessity as a circumstance precluding wrongful?
Necessity article, yeah, so go ahead.
The necessity exception.
Yeah.
In this case, the human necessity exception was always there in the ART. Both the Kingdom of Tempeh and the Republic of Seitan knew that there was this limitation and allowance to apply a limited welfarist regime.
Let's say you signed the treaty and everybody agreed that the standard of living was $1,000 a year in Tempeh. And the standard of living is still $1,000 a year in Tempeh. So what's changed? Why would you be able to invoke a provision that's applied to genocide, war crimes, the destruction of a society? Not that you disagreed with a reference to factory farming that seemed to be agreed upon in the original agreement. How does that rise to the level of necessity if there's no factual change in your means of production, in the way your society is run, that would have created a necessity? Let's say there had been a disaster, a volcano explodes. You can't provide food for the people. Well, okay, that would be a necessity by an act of God. But I don't see that here in the facts. To create the necessity that you need to rely upon to vitiate the treaty, tell me what they are, or tell me why I'm wrong. I hear that all the time. You can tell me why I'm wrong. It's fine. You know.
In the case of the human necessity exception, it is not necessary for a change to have happened. Mm-hmm. It was already there by the time both parties ratified this treaty, and therefore the Republic of Tempeh knew of this necessity and knew that its economical and cultural traditions could be respected through this necessity.
But on that, so I think that's a plausible reading. But then the question arises: did you sign this treaty in good faith? Right? Were you actually intending to change anything in your practices? I mean, the applicants argue you've actually been retrogressive, but let's assume you even haven't been retrogressive, but you haven't made progress. Was your intention, given that that's your interpretation, that you don't need to show that anything has fundamentally changed, to justify it? In what way are you implementing the treaty in good faith?
We're implementing the treaty in good faith because the principle of good faith establishes that we must implement this treaty, but we cannot cause a systematic harm and a crisis within the Kingdom of Tempeh. Mm-hmm. We understand that this is a transitional period for the Republic of Tempeh to put into effect the ART's obligations. It has only been 1 year since we ratified this treaty, and we must remember that socio-economical context of states should be considered when assessing international obligations. We cannot compare ourselves with the Republic of Seitan, which has historically have a plant-based agriculture system and that already has the funds and all the innovation to implement this kind of industry in our geographical region.
When you say culture, well, what can you unpack that for us? What does that mean?
Yes. Culture is actually one of the rights that allows the reservation to be applicable. In this case, it says that people have the right to partake in cultural life. If we prohibit especially aquaculture and fishing is severely limited, how can the Kingdom of Tempeh has the resources to practice their cultural traditions, such as our national dish that is based on fish?
Most of the isms that we look down on, whether it's racism or sexism and variety, speciesism, whatever they are, they're all culturally based initially. And so culture will never change unless it's challenged. And obviously a treaty like this challenges both sides, but that's one of the problems I always have with a cultural argument. How do you address that the point of this treaty is to change culture?
We must understand that the Kingdom of Tempeh has a long history of animal consumption, and the change in culture will not happen from one day to another.
What if this court adjourned this case for 5 years and said, 5 years from now, we want to see what progress you've made on these cultural changes that you said you were going to make? How would your applicants feel about that? We're going to adjourn it for 5 years. We're not going to grant judgment to anybody, and you're going to come back and tell us what cultural changes you've made and what progress you've made.
Yeah. I think the Kingdom of Tempeh has to start with an awareness campaign.
Mm-hmm.
We cannot change the minds of people if we do not teach them why animals are sentient beings, and that's the very first start to change the culture.
Okay.
I'm worried that you're sort of adopting a gloss really in your reading of the reservation, because the reservation is about the conflict with the kingdom's existing human rights obligations under international law. So is your submission really that you've been obliged to allow this growth of intensive animal agriculture over the last year, because to fail to do that would be a breach of your international human rights obligations? That seems a really exorbitant submission.
Tempeh has human rights obligations that are vital for the functioning of our society and are vital for our citizens to be able to live. This process of the ART implementations takes time. We cannot change our economical circumstances one day to another to feed and be able to feed and ensure work for all the people that work in animal agriculture and aquaculture. We must respect these human rights treaty obligations, otherwise our civilization could enter into a crisis.
If your existing human rights obligation at the time you signed were already such that prevented you from making progress, right? Is it not the case that you're relying on the reservation to essentially bar an awareness campaign, do nothing?
Our submission is that this reservation does not go against the treaty's purpose. Our reservation still allows animals' rights, especially those set by Articles 17, 26, and 35 of the ART, to be allowed to put into practice. This particular case is about the prohibition of animal agriculture and aquaculture, and that is the issue we have. We could implement other welfare standards to comply with the ART obligations. It is not necessary to make a complete prohibition of these practices.
You've challenged your opponents for failing to make an objection, and you discussed the sources, the law on objections, and the famous 12-month or 1 year time limit for doing it. But Finally, does it make any difference whether they've made an objection or not? You're asking us to apply the reservation to your obligations. Even if they'd made no objection, even if they'd not even raised the issue of the content of the reservation, are we still entitled to consider that it's flawed and possibly even contrary to the object and purpose of the treaty? How could we apply a treaty if we thought that you and give you a free ride on one issue because you've made a reservation that doesn't appear to us to be even lawful?
To address the first issue, our submission is that the fact that the Republic of Seitan did not object the reservations is not in relation to the admissibility of this reservation, it's in the relation of the existence of a dispute. The Republic didn't let us know that there was a dispute in this case. Now, concerning the issue of the admissibility,
I'm not convinced because making an objection isn't a dispute. You're just saying we don't recognize the validity of it, and that's it. There's no mechanism in the Vienna Convention on the Law of Treaties for responding to an objection. It's just a fact. So I don't see why that even is evidence of a dispute.
it will be an evidence of a dispute because it will show that we have different interpretations of what the art's purpose and meaning is. Our reservation does not go against the core purpose of this treaty. The core purpose of the treaty established in Article 1 is the protection of non-human animals' rights. Our reservation is just about a particularly instance where human rights can limit animal rights, but both human rights and animal rights has limitations. It has always been that way. Thank you, may I please the court.
Mr. President, Your Excellencies, it is an honor to appear before this honorable court in behalf of the Republic of Seitan, the Republic of Tempeh. I will address the two remaining issues. First, I will demonstrate that Seitan lacks jurisdiction to bring this case, and second, I will submit the argument regarding the wrongfulness, the acts that precludes wrongfulness. In a matter of legal standing, Your Excellencies, the Kingdom of Tempeh submit that Seitan lacks the legal standing to bring this case. In accordance with established international obligations, the states that invoke the responsibility of another should accomplish specific requirements that are codified in ARCIWA, and particularly in Articles 42 and 48 of that document. Article 42 regulates the legal standing of states that are considered injured states, and Article 48 regulates the legal standing of states that are another than injured states. In this case, none of these articles applies. First, Article 42 doesn't apply in this case because it regulates the cases when the obligation is owed to a particular state, like in the case of bilateral treaties, and also when the obligation is owed to a group of treaties or the international community as a whole. Article 42 regulates the situations where the obligation breach is such a character to radically change the position of all the other states. This is also not the case, and optimus case for that situation would be, for example, a disarmament treaty. Also, Article 48 doesn't apply. It regulates two circumstances. First, situations where the obligations are owed to international community as a whole, or when it's owed to a group of treaties, and it's regarding a common concern or a common interest of that state. None of these situations apply. The first one I mentioned is erga omnes obligations, and the second one is erga omnes partes obligations.
Let me stop you. We have a question from Judge Schemmer.
Thank you so much. So, Council, I'd like to draw attention to this court judgment in Gambia versus Myanmar, where there is definitely a line of similarity between the Genocide Convention as well as ART. So, if you could kind of walk us through, in a sense, like in a Genocide Convention, if we say that there is jurisdiction in absence of an individualized harm, how is ART any different, and why wouldn't those principles apply here?
It is different because in Gambia versus Myanmar, the International Court of Justice established that in these type of obligations, the common interest and the purpose of the convention is the reason of the existence of the convention. And in this case, there are no obligations owed to one state to another, and in this multilateral treaty, there is a common concern that is animal rights and the protection of animals, but it's a general concern that doesn't give automatically legal standing to all the states to invoke the responsibility of another. This conclusion would give us to a consequence, for example, to accept the actio popularis, which is also problematic because it makes so flexible the legal standing of countries.
So it might be that not all provisions in the treaty give rise to erga omnes partes obligations, but they claim Article 12 specifically, given the set of rights that are entailed there, does. So can you address this directly? Why should we not consider Article 12 to give rise to erga omnes partes obligation?
It is not a direct mention in or a different or particular characteristic in Article 12 that make it different for the rest of the treaty to make it erga omnes obligations. It does talk about the object of the treaty, which is establish an abolitionist regime between states. But it is also, as I mentioned, just a common concern of the states, but it's not give specific obligations to the state to apply or to comply with these obligations between others. In the world, the animal rights have in this time more recognition than another times in the past, but we can see that this is not common. For example, by comparing similar cases in different states that has different solutions between the national courts. For example, we have the case of Sandra in Argentina, the case of Mona Estrellita in Ecuador, and the case of Sandai in Chile.
I thought that case was that case decided by the trial judge, but then on appeal, it wasn't. The trial judge's opinion wasn't affirmed. The court made a different basis for its decision, a more restrictive decision than the trial court had done. Is that right?
The habeas corpus and recognized that Sandra is a non-human person.
Mm-hmm. Okay, you go ahead.
This is the case when the habeas corpus was accepted. As my co-agent previously stated and makes clear, this is no such a thing as a breach of an obligations under the ART. But even in the case that these courts consider that there are breach of these obligations, there are some circumstances that preclude the wrongfulness of that actions. These are the cases of necessity or distress that apply in that case. Companies' traditions, economy, and national identity are deeply rooted in the use of animals for sustenance and work. As a consequence, this is not a mere matter of state will or legal design. It is a social structure, a historically entrenched reality, and this is not easy to change. prohibiting animal agriculture would generate catastrophic consequences to our country. Widespread malnutrition, massive unemployment, and the collapse of our national economy, which relies in this industry for over 60% of our gross domestic product, any prohibition would be likely rejected by the population, as confirmed by national surveys. This respondent respectfully praised this court to declare that the Republic of Seitan has no legal standing, that the Kingdom of Tempeh has no breached its obligations under the ART, and ordered the Republic of Seitan to pay the cost incurred by the Kingdom of Tempeh in the present case. Thank you. May it please the court.
I think there was a little bit uncertainty when you were asked to delve deeper into the citations that you were making. I want to commend you on your time management. I thought you did that really well. You stuck to your structure. I think you would have been more impactful in arguments if you had been more descriptive of the animal cruelty. In some questions, I didn't find that I had direct answers, but I really want to commend you did so much more better than I would have done.
I like the fact that we in both cases kind of threw at you questions kind of quite quickly, and sometimes ones that were not exactly in your kind of prepared line as you were planning to progress, and generally speaking in relation to both teams, not through you, of course. So I'll come to one point about structure in a minute, but I think you've handled and you've also, I think you've been attentive. You saw that there was someone about to ask online even before we pointed it out. So you are aware of what the judges are doing and wanting, and it's, I think, very important in court. So to kind of the applicants, yeah, I thought the presentation skills in both of your cases were really good. I think what I would, and this kind of links to a point I think Shreya was making, I would have wanted a little bit more maybe grounding in the text itself. So as you go along, so it's in terms of citations as well, we base this on this provision, or we base this on this case, on this specific things, rather than in a way waiting for us to ask what is the authority provided, right? And it might be that it's in the written submissions, but the point about the oral submission is to link the argument with the source, right? And that's ultimately how law works. So I think that I would have wanted this perhaps a bit more, and this is a point I think that goes to both teams in terms of how you divided your time. It's very clear why the respondents do want to focus on this, but for you guys, I think you felt the need to deal with preliminary issues, particularly around jurisdiction and reservations, but maybe in terms of how you allocated the time, that could have worked a bit better. And you always kind of responded kind of with grace, so I thought that was really good. The two things that I might suggest constructively is, one, in terms of both the internal and the kind of team-wide structure. Again, that might be clearer from a written submission, but even when you speak orally, to lay out, to spend 20 seconds, at the start saying, I'm going to be speaking first about X, second about that, and then I have spoken about X and Y, and my teammate is going to be presenting these 2 points, right? Just to give us, in a way, subheadings as we go along to kind of see where you are in your 20 minutes. You don't have to commit to how many on each topic, but I think that would be constructive, and I think you've tried to deal really, in a way, bravely with the culture point, I think, which obviously was harder on your end, kind of to try and reclaim the narrative, try to say we don't hate animals, right? It's just going to take time. It's a hard balance to strike, right, between kind of, in a way, suggesting because of the culture, whatever we've signed up to, we can't actually implement because it's not fitting for our community. And at the same time saying we're making efforts, this is only one area. I think you've done well, actually, but it's just something to be aware of because it's inevitable that this will come up in this particular context. But overall, well done.
I thought to be able to do what both teams did in English and respond to all the questions, some of which were quite complex questions actually, and was amazing. So congratulations to all of you for that. I also thought that both teams had really beautiful style. Like again, to be able to deal with it in another language under pressure, standing here with all these people in front of you, and to maintain the poise that you did was really remarkable. So those are, respect to all of you for that. In terms of giving in terms of giving areas for possible improvement, let's say, I'm going to direct this mainly to the applicant in the first instance, but because actually a lot of the points I think apply to both teams, the same points. I think you've got to bear in mind this is a legal exercise. It's not a policy-based debate, and law is ultimately about legal logic and following the thread through, and just being really clear about what your argument is based in this case on the interpretation of a treaty text. You've really got to engage with the text and think about, what does it say? What do the actual words mean? What does necessity mean in the context of this provision? And set that out right at the beginning. Also related to that, although in the Moot problem it's given you a series of different arguments, that you shouldn't just view them in isolation and think, well, how am I going to argue this? And then the treaty means what the treaty means. The judges are trying to give a coherent interpretation to the whole thing. So just having a really clear idea in your own mind about how it all fits together. Setting out your structure as well about what you're going to cover in your presentation actually really helps you to limit judges' questions, because judges then won't be asking you questions that are off what you prepared, because you've been clear about what your structure is and where you're going with it. What I would say to you is that when you're in the position of respondent, you're making your case after you've already heard the other party's arguments. So if you want to get the really extra points, pick up on things they've said in their argument and answer their points. And also, if you listen carefully to what the applicant said, they made loads of concessions, perhaps ones they didn't intend to make. And you could have said, in answer to some of the questions you were asked, well, actually, that's not a point that's being taken by my opponents. They've conceded that point. The same goes actually for the rebuttal. The rebuttal is not a repetition of what you've already argued. It's a chance to reply, pick up concessions. And so that's why, rather than just think about making your own arguments, you've really got to listen to the arguments that the other side's making, so that it's sort of dynamic hearing. And also just making sure there's kind of consistency between the arguments that both counsel are making. For example, on the cultural point, I wasn't sure if there's a tension between what was being said about whether you were relying on cultural rights as a human right that therefore plugged into your reservation, or whether the cultural issue was sort of a background to broader policy considerations. So, sorry, that's my those are my points. But overall, really well done.
The give and take we have with all the questioning is actually not what happens in real life. It does in many courtrooms, it does in courts of appeal and so on, in domestic systems. But at the international level, they don't ask questions. It's theater. You just get up and try and read a speech that, amongst other things, because you're there as a lawyer for a government, they've had to approve before you said it, because it's binding the government. And so when I've acted for states in the international courts and tribunals, you have to write out your speech weeks ahead of time, and it goes through various layers of approval, and you can't depart from it. So when they ask you a question, which is not always very common anyway, sometimes there are no questions, but when they ask you questions, they say, and you can get back to us in a few days with the answer, because you have to check with the capital. So, I mean, I understand this is all pedagogical, really, and that's why we do this exercise. And it's also part of advocacy in most domestic courts, but it actually isn't at the international level. What do you have the memorials of the other side when you're? You don't see them. Okay, so I'll forgive you then for not challenging on them. Because one of the things that you can do when you're the applicant, when you go first, is you say, well, the memorial of the other side says this, but that's just wrong. And they must have got that site. They must have had ChatGPT prepare that chapter, and they invented some footnotes. You really do try, and it can get quite nasty, because although you should be courteous with counsel for the other side, and often they're your friends. It gets quite aggressive at the international tribunals where you're, trying to humiliate and embarrass the other side. I've seen this in real life. But you did have the opportunity, once they had spoken, you had the opportunity as respondents to go after them and to say, well, they, take note, cash in on their admissions, as the point that's just been made, and also to say that they are wrong about this or they missed the point or something. And, both of you fell short when it came to the rebuttals, because you could have said, we didn't have anything new in her rebuttal, so I'm not going to waste your time. Thank you very much, and sat down. Now, it was fine what you said, and maybe it was good to actually go over something, but you could have at the very least said, nothing new here. There's nothing for you to reply to. If you'll, with your, permission and with all due respect, let me just recapitulate something. I guess you could have done that, but more of that engaging with the other side.
You're all too nice. Just tell you that. You're all too nice. Destroy your opponent, and then when it's afterwards, buy him a beer and say, nothing personal, but listen, everybody gave you extensive criticism and extensive praises, but just three things. This is to both of you. When you come up to argue before us, you have deeply prepared arguments, but most of the jurisdictions that you're arguing are not going to be like an international court. And changes in animal law are going to happen just like they did in my state, and they're going to happen in sovereign nations. And so usually where you argue, it won't be in a treaty context, but it will be in an advocacy situation, particularly in any of the common law states. So if you're doing that, don't just think about what you want to argue. You got to think about what the judge wants to argue about, what the judge cares about. Always think that. When it's a common problem to come up and say, I've got to get through these 4 points and I got to tell you this. Oh, no. If they throw something at you, because you know what the issues are, we all know what the issues are, just whack it. Just whack it out and revel into the questions from the judges, because that is how you win cases, because that's how you reach into their heart and say, you're wrong or you're right. I love it when someone says to me, you're wrong for this reason, Judge, or you're partially right and this is why. Go ahead and do that. Be their intellectual superiors. You know this case better than all of us up here, and don't be afraid to show that to us. So that's the first thing. The second thing is, and this applies to both your arguments, personalize them. Don't intellectualize them too much. I think that that's what moves people. That's how you win cases. You win cases by personalizing it. If you had said to me, the animal life, let's say I'm the applicant. Animal life will be destroyed, and this is why. And this will be the personal effect to me. And if the respondent had said to me, we will lose 15% of our population if we go to this, and that will mean that there'll be a collapse here. And now you got into some of that, but personalize it as much as you can. Don't be afraid of that. I love asking unfair questions. So you get these unfair questions, you go, come on, I can't answer that. Well, of course, you're in an animal rights seminar, so of course it's a really unfair question. And that's why I'm going to ask it to you, because I want to see how you respond to it. Unfair questions are what advocates have to learn how to handle. And you are all going to be superior lawyers, but that's the pride of an advocate. That isn't true in every style of argument, but in an advocacy situation, it is. So keep that in mind. But positively, team one, your detail was superior. Your organization was superior, and it was very impressive. Team two, your philosophical argument, see, I liked your philosophical argument at the end. And I thought it was a strong argument because it wrapped up everything in a way that really got to the heart of what you were seeking to do. So, and when you were on that territory, I thought that was strong ground for you, particularly like all the other judges have said, particularly because you had the tougher side of the equation. So, all in all, this has been a very positive experience. I hope for you, and it has been very much for me. You know, you are all tremendous advocates.
Thanks very much.
Thank you.